Welcome to the Senate Judiciary Committee. We are going to start off with a word of prayer from Reverend Calzard. Floor is yours.
Bow your heads with me, please. Lord, thank you for this day, and thank you for all the wonderful friends we have here. Thank you for this process that we have in the state of Georgia to look at all the needs and desires of our citizens and try to form good public policy. Help us to be mindful of those that are needy and give you the praise for everything. Amen.
Thank you for that. Before we get started, I want to recognize one guest judge we have, Judge Brenda Weaver from the Appalachian Circuit with us. Judge Weaver, if you want to stand up, wave at everybody. Remind me which counties you have.
That's Fannin, Gilmore, and Pickens County.
Fannin, Gilmore, and Pickens. Good to have you.
Way north.
Way north. Well, good to have you down here today with us. Also, if I could take a point of personal privilege, Judge Stephen Knights from Henry County State Court is with us with his 3 boys. Y'all stand up. Thank you all so much. It's their second time. They came last year. I believe it was last year, right, for a hearing as well. Second time having them up from Henry County. Good to have you all with us tonight as well.
So thank you, Senator Strickland, and just wanted to point out, thank you all for everything that you all are doing here, Senator Strickland and everyone else. I ran into an old buddy of mine, Robert Smith. We used to be VAs together back in the day.
Yeah.
It's a small reunion.
That's right. Well, thank you. Appreciate all the support you give us, too. Thank you for what you do. Thank you for bringing your sons up here again as well. Good to see you all. All right, we are starting to move House bills. So we're going to go a little bit out of agenda because we are going to do whatever these House members need to get their bills moving, because y'all doing the same thing for us on your side. And so Representative Leverett, we're going to go a little bit out of order and start with his 2 bills. House Bill 375. If you want to come on up. And this is a bill that we heard last year. You brought us, 10 bills, literally, I think, last year?
I think it was close to that number, Mr. Chairman, and you were very solicitous of my bills, and I appreciate you and the committee's consideration.
You had so many that we couldn't get them all off the Senate floor, but we're going to try again on some of these.
Fondly we hope and fervently we pray, as they say, Mr. Chairman.
All right. So we're working off LC 491591S, is that right?
That's correct, sir.
All right, the floor is yours.
Thank you, Mr. Chairman, and thank you, members of the committee. House Bill 375 is a bill that this committee heard last year. At least it heard section, I believe it's section 9 of it. I'm sorry, section 13. We've added another bill to this one. We've incorporated House Bill 291 into this. That bill passed Senator Kirkpatrick's committee last year, I think after she did some of that good old Senate perfection of our House bill. And we just thought they're both very similar, so we decided to combine them into 375. So original 375, the section 13, which is on pages 16 and 17 of the bill, basically helps define the term gross settlement in the statute relating to powers of a conservator for an adult ward. And the reason for that is we made some changes a year or so ago in some of the definitions with respect to minor settlements, and to avoid there being conflict or some confusion because of the difference in those definitions, we're just kind of cleaning that up now and making it clear that the gross settlement includes medical expenses and expenses of litigation for purposes of determining whether the conservator has authority to settle the claim on his or her own. The remainder of the LC before you, 491591S, is actually House Bill 291, which was a bill that was filed by Representative Scoggins last year. And it was the main purpose there was to expand the list of providers who were listed in the code and that could be appointed by the court to evaluate wards for guardianship proceedings. So we've got a great deal of similarity between those 2 provisions. The problem that House Bill 291, or the remaining sections now of House Bill 375 that's before you, the purpose was that courts are being overwhelmed with guardianships because they're having difficulty finding licensed physicians or licensed psychologists to do the evaluation. This adds additional providers who can perform the evaluation to licensed physician assistant, licensed master clinical social worker, And so they're now allowed to handle those assessments, so we can try to alleviate some of the backlog and give probate judges an alternative appointment when they are making those decisions. So that, in summary, is the bill. And I'll be glad to stand for any questions. And I've got Ms. Gianna McConnell with me here today. She represents the APRNs and the licensed counselors, and she might, if you have some questions, I might have to phone a friend and ask her to take it.
All right, you have a question from Dr. Watson.
Just for a point of clarification, in looking at all of these, I'll say pick line 185, chapter 39, and title 43, and then it had listed a physician, it had listed a psychologist, and then if you skip on down to line 189, it says or a licensed clinical social worker. So a licensed clinical social worker was already on that list, and all you did was add nurse practitioner, clinical nurse specialist, and psychiatric mental health license, or family marriage family counselor, or an LPC, professional counselor licensed. So that's what you did, basically. Just expanded that list, as we have done in several aspects related to the law, and especially when we were doing 1013 and others. And prior to that goes back years. So sounds like you've done a good job. Hopefully you've expanded that, made it, I don't want to say easier, but made it more productive.
Thank you, Senator. I wish I could take credit for all that, but I'll allow you to lavish the praise on me anyway. I believe it was Senator Kirkpatrick and I'm assuming probably Ms. McConnell and those groups who deserve the credit for this, but thank you very much for that observation.
Maybe now your bill could pass.
Who knows?
Yeah.
Who knows?
Yeah.
The unthinkable can happen.
That's right. Any other questions from the committee? Senator Calzert.
Thank you, Mr. Chairman. Just a quick one, because I hadn't memorized the code like you have, Counselor. There's on lines 406 and again on 412, you're striking through a definition in Code Section 2933. That's not in this bill, and I hadn't researched it. And I get the new definition of the gross settlement. How does that differ from 2933?
Well, I think there's an argument that it really doesn't differ, but I think a probate judge that I am acquaintance with was concerned that there could be a problem of construction, and he wanted to clarify it. So that's why I had filed that 375 in its original form. Okay.
I like the definition.
I think to his point and your point, I think it's a good definition, and it's a little clearer. Although I think you could reach the same result with the existing language. This was just to try to clarify it and avoid any controversy. I'm assuming he had that argument before him and was wanting to not have it again.
Fair enough.
Any other questions from the committee? All right, no one else decided to speak on the bill. What's the pleasure of the committee? Motion do pass by committee substitute from Senator Watson and a second from Senator Calzert. All those in favor of the motion, please raise your hand. It is unanimous. I looked, and our notes show that Senator Rick Williams was going to carry 375, but then we had Senator Sam Watson that was carrying 291. Have you spoken with either one of them about who's going to carry it?
I have not, and I will try to do that and report back to your office if that's agreeable.
Okay, that works. All right, next one is House Bill 523, and we are working off of LC 442294.
That's correct, Mr. Chairman. I guess today the theme of this can best be summarized by the Jerry Lee Lewis ballad, "One More Time with Feeling," because these are both the 375 that you just heard did have some changes, but it was in a core a bill we did last year. 563 is identical. It's the exact same thing this committee passed out last year. Ms. Alana Cross is here with me, who's the director of the Commission on Equal Opportunity. The main purpose of this bill, and she can talk a little more about it, is to give the commission a less expensive alternative to hearing these types of complaints or claims than special masters. Instead, they would like to use the Office of State Administrative Hearings. And so that is one of the primary sets of changes you'll notice through here. There's a definition of hearing officer that is an administrative law judge for the Office of State Administrative Hearings, unless the complaint before the EOC concerns the Office of State Administrative Hearings, and then they will still use the special master. And then there are a few other tweaks we're making in here to some of the process provided in the hearings. We're trying to provide that complaints can be amended rather than requiring another new complaint to bring any additional evidence or charges or changes. And we're providing, see, what was the other one? There were amendments and there are provisions on allowing the judge to compel production. And because we're going to be using the Administrative Procedure Act now, there are already provisions in that act governing testimony and evidence and discovery. And so we've deleted some of the provisions in these code sections that are particular to the commission, because now they're going to be using the more standardized version. So that's basically the bill in a nutshell, Mr. Chairman.
Anything you want to add, Ms. Cross?
Well, good afternoon, Mr. Chairman and members of the committee. My name is Alana Cross, and I serve as the Executive Director of the Georgia Commission on Equal Opportunity, Office of the Governor. It's a pleasure to be here with you all today. As Representative Leverett stated, the bill is aimed at amending the Georgia Fair Employment Practices Act to essentially clean up legislation. Notably, to my knowledge, the act has not been updated since 1978. So as you can imagine, the need to improve and update processes and procedures is vital to ensuring that the Equal Employment Division can operate and function effectively. The bill primarily addresses modifying the current special master process by redirecting probable cause cases to the Office of State Administrative Hearings instead of appointing a special master to hear those cases. This change is necessitated by existing budgetary constraints, and the Office of State Administrative Hearings has a more cost-effective process for hearing for conducting the hearings. And so essentially by modernizing this act, we aim to create a more accessible and responsive system for individuals and stakeholders involved. So thank you for your consideration, and I look forward to answering any questions you may have at this time.
Are any questions from the committee? Senator Setzler.
Thank you, Mr. Chairman. I'm working off LC 442294. I'm on lines 78 through 83. And you'll have to help me here. Talks about right now that talks about examining witnesses, interrogatories. It talks about requiring production of documents, but now it's invoking a discovery process. Is this essentially a full discovery process that's not within the powers today?
Yes, so this is currently the complaint investigative process, and right now there is not an enforceable discovery process now. And so there's been issues with being able to enforce the statute, and this is adding that enforcement piece. So we'll have better enforcement for complaints and the investigations we conduct.
That's pretty hefty, isn't it? I mean, compared to where you are today, that's a pretty hefty move.
Well, currently, the Georgia Fair Housing Law, which is the housing division, also within the state agency, has that ability to enforce discovery as well. And so we're trying to make both laws substantially equivalent to each other.
Okay.
If I can respond, it is certainly a change. I don't know if I would characterize it necessarily as hefty, because for the commission to be able to do its business, it's got to be able to require production of documents and evidence that are relevant to the investigation of the complaint. And without that, they really can't. They can't function.
These are true questions. These are not leading questions. I'm just trying to understand where this is relative to other executive powers versus, kind of a judicial order. There's who's refereeing this. I mean, if you're in a civil setting and you ask for production of documents in a civil setting, there's a judge that can adjudicate. No, you don't get that. You can get this. But who's adjudicating here?
Mr. Walker has a comment.
I'm sorry, Mr. Chairman, it's not on this.
Not on this. Okay, I thought you were telling me on this. Okay. Disregard. I was going to say, though, that currently, if you look at the current code, 78 through 79, we already have interrogatories, the right to examine witnesses, and require production of documents without saying the whole discovery process is in place. I think the intent was to make it clear how that would work versus it being open-ended. Is that right?
Absolutely.
Okay.
Currently, parties involved, such as state agencies, state colleges, and universities, and some local municipalities are already cooperating with the discovery process with responding to interrogatories. And this is just making sure that it's enforceable for everyone and making sure everyone is providing their information during the investigation.
I understand. I mean, everybody on this panel wants good things to happen. I'm not saying we don't. I'm just saying, when you're in a civil setting, you do have a referee there, and I'm just sensitive to executive agencies sort of being the, hey, we're ordering you to produce these documents because it's an investigation we're making. It's almost if you're giving the judge is getting in the game, taking his robe off, getting in the game, and ordering the production of documents that he's going to go investigate, as opposed to being the mediator between parties. It just gives me pause. I don't know that I have an opinion on it yet. I look at that and I think judges are normally referees of such things because people ask for all kinds of things in discovery, some of which is, they could make a straight-faced answer that it's reasonable, and then the judge said, you get these three things, but this, no. So I just trying to weigh it out.
Well, Ms. Cross may need to address that because I've never actually litigated a case in front of the commission, but I would assume if I felt like they were overreaching, my remedy is just to refuse it. They would make a finding, but then I can appeal that.
And that's exactly what happens.
So how does you could do that through the interrogatories now. When you give the power to order discovery, who adjudicates whether that order is appropriate or not?
It goes to the office of. It would go to the Office of State Administrative Hearings because this is during the initial investigation.
During the initial investigation, there is no one to adjudicate it during the initial investigation. We're wanting it to go to the Office of State Administrative Hearings in the event it's a probable cause case.
So I would think your remedy would be just to refuse to provide the documents. They would, if they make an adverse finding, you can then appeal that to the Office of State Administrative Hearings, in which you would be able to challenge the order for production of the evidence. I don't think they've got the right to come after you if you don't produce the documents. They can't hold you in contempt.
Has the person who's receiving the interrogatory that's being told to produce documents, have they lawyered up yet? Have they secured a lawyer? Have they put $15,000 in escrow for a lawyer when this happens?
Most of the respondents are state agencies, state colleges and universities, and some local municipalities, and almost all are represented by general counsel or the attorney general's office. Yeah. And so they all acquiesce to the interrogatories.
And that's the extent of the commission's jurisdiction.
That's the extent of our jurisdiction.
I don't think they can hear a complaint against a private employer.
No, right now it's just state agencies, state colleges and universities, and some local municipalities that receive significant funding from the state.
All right, Senator Calvert.
Thank you, Mr. Chairman. I had questions on page 7. Two different places you strike through current law's requirements that actions be taken within 90 days. I've got this vague recollection that there were at one point a lot of complaints and the delays in getting rulings, and these were put in there to trigger and force action in a timely manner. Why are we removing that at lines 152 and 161, the 90-day trigger?
Taking the status report out there.
Yeah, first the administrator had to give a status report every 90 days to let the complainant know what was happening, and then if the administrator didn't either dismiss the complaint or announce a worked out deal within 90 days, they had to refer it to now an administrative law judge and then a special master. Now it's either or, apparently. I just wonder, why did we alleviate or relieve them of the timeliness of taking action?
I think Ms. Cross can address that, but my recollection is the status report itself was time-consuming, intended to delay the ultimate disposition of the case. So that's why we struck in 52 through 55. And the 90-day deadline in 161, I think Ms. Cross we've discussed that, but I can't recall what the exact reason was now.
So for the investigative process, it's still 90 days. This is being strike through because there's been some ambiguity and interpretation issues by different parties. And in this particular case, the individual wanted to go before a special master simply because the case was not completed in 90 days because he misinterpreted this language in the statute. So that's just clearing up that ambiguity and misinterpretation of the statute to say that if your case has been closed, we found no cause on it, or if there is no conciliation agreement or probable cause, your case is dismissed and your administrative process with our office is concluded. But that individual wanted to have those rights that were not established for him, despite just simply because the case wasn't completed in 90 days. So that's why we changed that language for interpretation purposes.
One final question, Mr. Chairman. Okay. On page 9, lines 207 to 210, current law requires that testimony at these hearings be under oath and stenography, a court reporter has to transcribe it. You're eliminating that. And I wonder why, because how would you ever be able to have an accurate appeal without having a record of what the testimony had been at the hearing?
Agreed, and you'll notice we're striking in 195 through 200 some provisions there, but that's all because the Administrative Procedure Act already addresses all those issues. And what we're trying to do with the bill is move into hearing officers instead of special masters, and hearing officers use the Administrative Procedure Act, which already addresses all those issues.
Does the Administrative Procedures Act require stenographer and sworn testimony?
All of that. So leaving that in there would be superfluous. It would be repetitive. And so we're just trying to clean up the language since we'll be moving towards that Administrative Procedures Act.
Okay, thank you.
Thank you.
Any other questions from the committee? All right, no one else has signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Senator Watson. Do we have a second?
Second.
Second from Senator Parent. Mr. Walker?
Thank you, Mr. Chairman. If the committee is so inclined, I would recommend a cleanup on line 41. The code cross-reference there is not correct. So I would recommend, rather than referring to subsection E of Code Section 45-1923, that we strike subsection E of and just refer to Code Section 45-1937. Code Section 45-1937 actually deals with the governor's authority to appoint special masters.
Okay. We have, it's line 41. You're on a different bill. You're on the other, the old one. All right, we have motion for the amendment from Senator Setzler. Do we have a second? Second from Senator Rhett. All those in favor of the amendment, please say aye. Any opposed? All right, back to the underlying motion. Do pass. Senator Setzler.
Just a quick question. So just to be clear, I'm reading through the existing code. So everything we're doing here only applies to public employees relative to public agencies.
Yes.
There's no color of law where it gets skewed outside of that.
No. Currently, we only enforce the law in terms of state agencies, state colleges, and universities, and some local municipalities.
Okay, cool. Thanks, Mr. Chairman.
All right, we're back to the motion to pass now as amended. All those in favor of the motion, please raise your hand. It is unanimous. Who's carrying this bill? I didn't look it up yet. Who's?
I believe Senator Anavitarte.
Anavitarte. All
Last
right.
year, I have not confirmed that with him this year.
I
but
think he would love doing it again.
Well,
so.
he was on the commission once upon a time,
right.
so we felt like he would feel like it was old home week.
Right. Well, thank you, Mr. Chairman. Appreciate
Thank
you.
you, Mr. Chairman. Thank you, members of the committee, and I appreciate you allowing me to go first, Mr. Chairman.
Yes,
Thank
sir.
you so much.
Thank you all.
All right, we're going to go back to the top of the agenda. Chairman Gunter, if you want to come on up. We'll start with House Bill 456. We are working off of a committee substitute. LC 481059S.
Correct.
All right, the floor is yours, Mr. Chairman.
Thank you, Mr. Chairman and members of the committee. I believe this is a judicial council bill, and what it does in section 1 on line 21, it sets a minimum term for a municipal court judge at 2 years, and adds a sentence that deals with that the agreement cannot limit them by geographic limitation, or they can't have a provision in there that they serve it at will. So basically, they get a 2-year term. And then in Section 2, the language that was added there deals if there's a breach of the agreement and sets out how it's handled. It just puts that kind of detail, and that's a little high view of it, but if y'all have any questions, I'm happy to answer.
All right. Any questions from the committee on House Bill 456? We do have one person signed to speak on the bill, Mr. Skin Edge. You can sit tight if you want, Mr. Chairman.
I'll be brief. We're here on behalf of the Council of Municipal Court Judges, and we support the bill. This is a bill we worked through with GMA, and all parties are in agreement.
All right, so the Council of Municipal Court Judges working with GMA worked together, and all parties are in favor of the bill. Any other questions from the committee? If not, what's the pleasure of the committee? Motion do pass from Dr. Watson. We have a second from Senator Setzler, and we do have a couple pieces of cleanup. Mr. Walker, you want to take them for us? Or?
Okay. Thank you, Mr. Chairman. On line 11, there's just a cross-reference error. The cross-reference there should be to Code Section 36-32-2 rather than 36-2-2. So that's on line 11. We would also recommend on line 51, striking the S from the word terms so that it would be singular, referring to a judge's term rather than terms on line 51.
All right. Any questions on the two proposed amendments that sound like one good amendment if everybody's good with it? Anybody want to offer the amendment?
So offered.
Senator Parent, second from Dr. Watson. All those in favor of the amendment, please say aye.
Aye.
Any opposed? Back to the underlying motion, do pass by committee substitute now as amended. All those in favor, please raise your hand. It is unanimous. And who's carrying this bill in the Senate?
I haven't confirmed it, but I've spoke to Bo Hatchett a while back on this.
Senator Hatch, he's walked out. He'll be good for it. All right. And Cowser's also available, we see now as well, so maybe the next one. All right, moving on to House Bill 873. Let's make sure we get ourselves straight. Also working off a committee substitute, LC 481132S.
Correct.
All right, the floor is yours.
All right, thank you. Joining me is the Anoka Circuit Juvenile Judge, Jeremy Clow. Jeremy and I go way back. I hired him a long time ago, and it was one of my better hires. So he's a sharp fellow. And he knows juvenile law. I don't. But having been a mental health court judge and a drug court judge in the Superior Court, I understand the concepts of what we're talking about here. And what I'll do is just give you a little high elevation look at the bill. And if you have any questions or need the details, Jeremy can handle that for you. But basically what this does is brings the juvenile court system under the Council of Accountability Court Judges. And we do that to set the standards and practices the same throughout all the courts. The juvenile courts have not been under the council, and over the couple of decades have built their own systems, and this will bring them under the standards and practices that the council puts forth.
I said one thing incorrectly when I said it's a committee substitute. It was a committee substitute on your side. This is as passed the House, I believe we're looking at.
Correct.
Is that right?
Yes,
okay,
sir.
I just want to correct that for everybody.
Yes, sir. Thank you. So they have to have a work plan. They have to include certain people to operate within the court. This also deals with the confidentiality of the information that is gathered while the child or the parents, I guess you could say, are under the treatment of the juvenile court. So that's kind of a high view of it. If y'all have any questions, we'll be happy to tackle them.
All right, any questions from the committee? All right, nobody else has signed up to speak on the bill. We're moving too fast and talking a little bit slower. That's okay.
If anybody on the committee is not familiar with the accountability courts, I strongly suggest that you find one in your district and go visit when they have a graduation.
Mm-hmm.
It'll tear your heart out sometimes.
I've done a couple of those myself. Yep. Mm-hmm. All right, what's the pleasure of the committee? Motion to pass from Dr. Watson, a second from Senator Kennedy, third from Senator Hatch, who's carrying the bill, I think. All those in favor of the motion, please raise your hand. It is unanimous. And is your floor leader in the Senate, Senator Hatchett?
Yeah.
Okay.
He is.
Do you want him to carry it really? You want somebody else?
No, if he's willing,
Okay.
that's great. Okay.
Thank you, Mr. Chairman. We'll be coming to see you soon, I'm sure.
Okay.
Thank you. All right. Chairman Yurda, come on up. House Bill 204. Back to municipal courts again.
All right.
Let me find where we are. Working off of LC 472993. And this was a bill we heard last year in committee, if I remember correctly.
That's correct, sir.
And
Thank
this
you,
is
Mr. Chairman.
Same version from last year, right?
Yes, sir.
All right, the floor is yours.
House Bill 204 creates a municipal court clerks council, which would be valuable to the municipal courts in Georgia. Currently, there are 389 municipal courts in the state of Georgia, and these courts are very varied. If you remember from last year, from Atlanta to many small communities that just may have courts once a month. Despite the diversity of these municipal courts, they all have to follow the same rules, and they have to be properly run in that respect. A properly run municipal court promotes public safety, improves the quality of life of citizens, and inspires confidence in the city and its leadership. This legislation empowers the GM, the Georgia Municipal Court Council, to have an entity that recognizes their needs for the municipal court clerks in the state. It will bring skill and competence to that organization and provide in helping them maybe seek grants and that kind of thing for the creation of a municipal court clerk certification program. So basically, it will aid them in education to help make our municipal courts better in the state of Georgia.
All right, any questions from the committee? Senator Kennedy.
Thank you, Mr. Chairman. Good afternoon, Representative. Good to see you.
Good to see you, sir.
Municipal clerks, are they employees or are they elected?
Municipal court clerks they're employees.
Okay.
Yes, sir.
Across the state?
Yes, sir.
So we don't have any elected municipal clerks?
No, sir.
Okay. Okay, thank you.
Senator Setzler? That wasn't you. Senator Jones?
It was me.
Senator Parent?
Thank you. Thank you, Chairman Yurda. I'm just looking at the substitute before us. Are you going to address Section 4, dealing with redistricting?
I don't have that in front of me, but we can do that. I don't have that particular information right in front of me. Thank you. Okay. What section are you referring to?
Section 4 on page 5, starting at line
Okay.
98.
All right.
And this may be something Senator Setzler could answer better, but I believe that when we saw this language before last year,
Right.
it was in response to an ongoing lawsuit. Is that the case?
I'm going to defer to Senator Setzler if you would like to come down and.
You can do it from up there. Senator Setzler.
Yeah, there's a case that's actually before the Supreme Court now. The Superior Court of Cobb County ruled that the purported home rule power of a county to apportion itself is unconstitutional. It was flatly struck down by our court, but it's an appeal, so it is before a Supreme Court. So I guess if we were to act on these sections, it would have the effect of settling that case. I mean, that's up to the committee whether that's the right approach.
That was my question, whether there was still ongoing litigation. I was familiar with the trial court's decision and just wasn't sure what the status was in terms of the case being played out in the courts.
I mean, the interesting case, Mr. Chairman, to the lady's question is that what was being argued by the county is the constitutional home rule power exists. So I don't think it was an issue. It was even a purported issue of statutory home rule power. So I don't know that we could change it with this. I don't know that adds more clarity to the legal mix to add. I mean, is it your intention to have this as part of the bill, or are you just trying to get a municipal court clerks?
I'm just trying to get a municipal court clerks through. If the committees I'm up to the will of the committee on this.
I mean, I think that just parenthetically, Mr. Chairman, I think the county's action humbly is lawless and reckless, but I don't know that we need to appear that way as a legislature by trying to interpose ourselves in this. Maybe we just deal with a single question and let the court sort it out.
Section 4, my memory was added last year, and in this committee substitute, it was not part of the original bill from the House, and so Chairman doesn't have an opinion. It's up to the committee if you want to take that out.
I mean, it's actually section 1, 2, and 4 is what we're talking about. 1 and 2 one's the findings. Section 2 is the operative provisions, and there was a tack on section 4. I guess the question would be, do we want to give the gentleman a vote on his municipal court clerk's council by itself, or do we want to add the other stuff in? So.
Yeah, the original bill is just section 3. Is that right?
That's correct. Yes, sir. And that would be fine with me if that pleases the group.
In the irony in this, Mr. Chairman, is in trying to move this last year to extend an olive branch to a member of the opposite party of myself, I was attacked by the opposite party of some kind of doing some trick, even though I was trying to extend an olive branch. So the messiness of this probably doesn't need to follow this bill. We ought to just pull those sections out and give the gentleman his underlying bill.
All right. Any other questions from the committee? We have 2 people signed to speak against the bill, and it may be related to those sections. Cindy Battles from People's Agenda. Do you want to?
Sorry, if they're going to remove those sections, then I can defer.
Okay, so it's about those sections.
Yes, sir.
And also, is it Jovan Davis?
That's correct.
Okay.
It was the same about that section.
Okay, with Common Cause.
Yes.
I both have concerns about the sections, section 1, section 2, and section 4 of the bill. Well, if we want to move the bill, we need a motion to pass first, and then we could take amendments to amend the bill to remove. Hold on 1 second. Even better, use the bill as passed. That's why we have people smarter than me sitting next to me. So you have the substitute for that. Senator Parent.
Yes, I would like to make a motion to pass on LC 442217.
And that
Which
is
is as passed the House.
As passed the House version of the bill, which would just have, again, section 3 from what you see in front of you. Is there a second?
Second.
Second from Senator Jones.
I don't remember any dates.
All right, a motion do pass and a second. All those in favor of the motion, please raise your hand. It's unanimous. All right.
Thank you.
Thank you. Wait, do you have something you wanted to?
I was just going to.
Senator Kennedy?
I was just going to ask Representative Yurda, our friend, to make sure when he goes back to the House to report how exceedingly kind the Senate Judiciary Committee treated you under Chairman Strickland's leadership, and how we removed things from your bill just to make them better so we could get them passed for you.
And I have something even better. We, of course, went back to the House version as they pass, and let's give him one more bill while he's here. How about that? So we can talk about two bills. Should we do that?
Actually, Representative, would you like fries with that while we're at it?
We're all out of fries, but we have the fruit side. So we're going to go, let's just pick one. What about House Bill 906? That's one that we might could look at. What do you think about that one?
Yeah.
You have any more beyond that?
No, this
Okay,
is
good.
going to do me.
All right.
This is a full meal deal. I bring you House Bill 906. This actually would create an extra or additional judge in the Tifton Judicial Circuit. Currently, there are 2 judges, and I think it's been since 1980 since we've had a new judge in that circuit. The population's grown about 25%, so the judges have a pretty tremendous workload, and they spend about 16 working days a month in court, and they're this year they're actually scheduled to have just as much or more. Currently, there are, according to my DA, Bryce Johnson, there are 33 pending murders in the circuit, 94 serious felonies pending. The Judicial Council of Georgia, of course, met this year, and actually the Tifton Judicial Circuit was ranked number 1 in the need for an additional judge, and that's basically the bill that would create that additional judge in the circuit.
We'll give him another judge as well. Why not? Senator, should we just do that too? All right. And so y'all were number 1 on the list of
We were.
rankings
Yes, sir.
this year. All right. Any questions from the committee? And thank you, Mr. Johnson, for being up here too. All right. What's the pleasure of the committee? Motion do pass from the pro tem. Is there a second? Second from Mr. Hodges. All those in favor of the motion, please raise your hand. You going to vote for your second? All right. It is unanimous.
All right.
All right.
Thank you so much.
Thank you. That's Representative Alexander. Yep. All right. One more. Representative Alexander, you want to come up? No, let's give him one more judge. Why not? Come on up, Representative Alexander. What do you have for us?
Thank you, Mr. Chairman and committee members. So I'm reading from LC 48107 at 2S, if you guys have that.
Yes, ma'am. That's what we had.
So
Said 1072S, right?
Correct.
Okay. Thank you.
This is a bill to add a 4th judge of the Superior Courts of the Douglas Judicial Circuit. The reasons for this legislation are because our judge, chief judge, is retiring at the end of the year, and he wanted to make sure that this was one last thing that he got completed prior to him leaving. Douglas County ranks number 3 for new judgeship. Currently, 3 judges are doing the workload of 4.5 judges for the past several years. Douglas County have not added a Superior Court judge since 1998. Also, the governor has included this 4th judge in the budget. If you look at the verbiage, it's the same language that mirrors other judgeship previously passed in the body, but Section 3, line 22 through 30, this verbiage staggers the term and allows for election in 2026. We currently have 2 judges on the ballot this November, so this would be in line with the judge, the 4th judge, the 3rd judge, so that would be the 4th judge. So those 2 would be for 2026. And wrapping up, Chief Judge McClain, as I indicated, he came with me at the hearing inside the House, and so he's retiring, and hopefully we can get this done and get this over and pass. But I want to thank him for his services with Douglas County. And Mr. Chairman and committee members, I will pause for any questions.
All right, any questions for Representative Alexander? All right. Nobody else signed to speak on the bill. What's the pleasure of the committee? Motion to pass from Senator Rhett. Second from the pro tem. Any discussion?
Thank
We
you,
might
Mr.
all be judges by the time we're done if we keep adding judges. Well,
you, Mr.
let's
Chairman,
take a
committee
vote.
members.
All those in favor of the motion, please raise your hand. It is unanimous. And I forgot to ask earlier, who's going to be carrying this bill in the Senate?
Either Chairman Brass or either Senator James.
Okay, so we got to pick between James or Brass. That's a tough call. All right.
Thank you, committee members and Chairman.
Thank you. Do you want to? Who's going to be carrying your two? Did you already get it from him? Your
Senator Setzler, I believe.
Senator Setzler.
204, and then the Judge Bill, Senator Summers.
All right, Senator Summers. Oh, do you want to try again? Or? Just kidding. All right. Well, Dr. Watson, I only met for about 40 minutes by the time all y'all got here, so it was pretty quick today. Maybe we should have done a few more, but health took a little longer than that today, I think, didn't it? To move how many bills? 2 bills? Yeah. All right. Well, with that, we're adjourned. Thank you.